Hello and welcome to the big picture. The higher judiciary in India has been in the news in recent times, more often for wrong reasons, causing a lot of consternation and concern among all sections of the people, and more so the legal fraternity itself. The recent instances which have been in the news are, according to many legal luminaries, a matter of grave concern. Unlike in the past when many such issues were more heard in the form of whispers, it is now increasingly out in the open. The allegations against the higher judiciary and now even some of the judges themselves being investigated for corruption and one even impeached and another one who was almost impeached are all out there in the open. What is more amazing is that judges have now started even making allegations against each other out in the open. At a time when there is increasing demand for a change in the appointment process of judges, more and more transparency in the functioning, as well as seeking accountability, such public display of differences and conflict within the judiciary has become a matter of debate. Today we will look at all this while asking the question, is the higher judiciary in India going through a catharsis? To discuss this, I have with me eminent jurist, senior Supreme Court senior advocate and former Attorney General of India, Soli Sorabjee, H.K. Dua, a Rajya Sabha member and an eminent former editor of leading newspapers of India, Professor Ranbir Singh, Vice Chancellor of the National Law University, Delhi, and Rakesh, Bhatnagar, senior legal journalist. Welcome to all of you. Let me go to Mr. Soli Sorabjee. Mr. Sorabjee, I think there is some problem with the line there. Okay, Mr. Dua, let me come to you. You think that this kind of open discourse which is happening now, which we are seeing more and more often now in the newspaper, in the media, about judges talking about each other and, some kind of hinting, even alleging against each other. Is this something part of a catharsis, or is this something which we need to be really concerned about?
I think they are not yet ready for catharsis. Catharsis is a readiness to change.
Yes.
There. I don't see any signs of judiciary changing. It has been the news for both good and bad reasons.
Right.
Some of the judgments have been very good judgments. Yes. It has been pulling up executive with greater enthusiasm in some cases, with less enthusiasm in other cases. But it has been prescriptive, telling executive to do and not to do some things. Do's and don'ts are being taught to Parliament also.
Right.
But itself is not going through the introspection, least of all catharsis. Now, that point is yet to reach. But there is a public disaffection against working of all the institutions, Parliament, judiciary, executive.
Judiciary was the last, bastion, some kind of.
Judiciary is the last hope of a common man. Kachari is the last hope. Unfortunately, it is disappointing. Particularly, lower judiciary, as you know, it's in very, very bad shape. Corruption is delays, corruption, piling up the cases. High Court also, then the problem reached to the High Court level. They are suffering from the same ill which lower judiciary was suffering. And now the allegations have reached at the Supreme Court level,
Absolutely.
which is very, very unfortunate.
And very
now, where do you go after Supreme
Where
Court?
do you go after? I think
there are many reasons for that. We'll come to it
We'll
later.
come to that. I think I have Mr. Sorabjee on the line now. Mr. Sorabjee, can you hear me?
But a little louder.
Yeah. Mr. Sorabjee, we were, I was asking the same question to Mr. Dua also. I want to ask to you. This public display of differences among the senior judges, not just in the High Court, but in the Supreme Court, is this some form of a catharsis which is beginning within the higher judiciary, or do you think that this is something else?
No, but differences are not unusual, except that they have received undue publicity in the press. Differences are bound to be. All judges are different persons with independent minds.
Right.
But the way it has been projected in the press doesn't give a good impression. I agree with you.
Mr. Sorabjee, it's not just.
But from that, don't conclude there's a catharsis.
No, my question is this. So when you talk of differences, when you talk of dissent, this is something which, as you rightly said, this is a healthy thing within the judiciary. People are different, they come from different backgrounds, judges also have their own way of thinking. These are all fine, but as long as it is confined to the legal aspects of what they are doing, the judgments that they are giving, and all that. But it has reached a personal stage where we read about very, very senior judges being allegations being made against each other. Isn't this something which is very unusual, which has not been seen in this country very often?
But I don't think there are allegations as such. There are questions of, well, one bench said to have observed that such an order should not have been passed. Very well. So that bench approved, rather expressed its disapproval. ठीक है. I agree with you. That also should not be said of another bench, especially when that bench recently passed the order.
Right.
But now judges do express themselves strongly when they feel strongly about it. But don't come to the hasty conclusion that uske liye, as you say, the catharsis.
No, in fact,
this is a healthy outpouring, but I agree with you, it should be in restrained terms and shouldn't appear as if one bench is criticizing the other order passed by another bench. That does not lead to the public perception and leads to a wrong public perception that the judiciary is widely divided.
yes, and Mr. Dua interestingly says, when I asked him the same question, that the judiciary, the higher judiciary especially, is still not ready for a catharsis. They need it. Apparently, when he says that, he implies that there needs to be a cathartic process, but they are not ready for it.
Sorry?
Mr. Dua feels that the judiciary is still not ready for a cathartic process.
Mr. H.K. Dua?
Yes. He is in the panel right here.
Uh-huh. Yeah, you didn't tell me that. I respect his views in all matters. And I generally agree with him.
Okay. I'll come back.
Soli. Thank you, Soli. That's the beginning.
Professor Ranbir Singh, you think that this kind of public display is not as Mr. Soli Sorabjee is saying, differences is good. There need to be differences. We can't expect judiciary to have uniform views on everything. But isn't this going a little too far?
No, for me, it is a matter of great concern as an academic.
Yes.
Because I believe that whenever we go to seminar conferences and people say we have about 3 crore cases pending in the lower judiciary,
Right.
and somebody say, I'm not worried. I'm not worried because that is also a sign that the common man in this country still has a lot of faith in the judiciary.
And
Let us not
he
forget
goes
that.
there.
And if you ask a common man from any village coming to a court of law and say, why are you going to the court? They'll say, I'm going to the court for justice.
Right.
So that is the last hope, as Mr. Dua remarked. And that means this kind of a discourse for me is very not only surprising but shocking and disturbing, because somewhere you find the faith of the common man shaken in the judiciary. If it happens at the Supreme Court level, I think we are in for a lot of introspection.
You constantly interact with young people. You're vice chancellor of a university. So all these law students, young people who come and join these law courses, what impact does it have on them?
No, I'm worried because we look for role models.
Right.
When I go to a class, I teach jurisprudence, constitutional law. We talk about great leaders. We say we belong to a profession. Legal profession has been a great profession, and let me illustrate that the freedom to every country, most of the countries in India and abroad, has been brought by lawyers. May it be Gandhi, may it be Nehru, may it be Lincoln,
Right.
may it be Nelson Mandela, may it be your neighbor Pakistan or Bangladesh.
Right.
So we belong to that profession, and we are supposed to maintain high standards of integrity. Let me take you to the self-imposed code of conduct, which is known as the Bangalore Principle.
Right.
And let me read to you that. Says, a judge shall ensure that his or her conduct, both in and out of the court, maintains and enhances the confidence of the public, the legal profession, and litigants in the impartiality of the judges and of the judiciary. Now, that is the standard which the judges have imposed on themselves. So if you look into various Bangalore principles, and this is a a self-written code of conduct by judges in various meetings, and which was discussed the national international level. And I let me also read another principle to you. A judge, like any other citizen, is entitled to freedom of expression, belief, association and assembly, but in exercising such rights, a judge shall always conduct himself or herself in such a manner as to preserve the dignity of the judicial office and the impartiality and independence of the judiciary.
Right.
Now, these are the two cardinal principles. And now, if you look into the present debate, in the backdrop of these two principles, I think there is a cause to be really worried about the things.
Rakesh?
Yeah.
You have been covering the highest judiciary for a very long time. Have you seen this kind of things happening in the judiciary in the past? Openly, this open discourse which is happening
See,
among the judges.
It is normally it is said. What is said is that if there are 10 benches or 12 benches,
Right.
so you will have 12 Supreme Court of India
Right.
under one roof.
Right.
So the very this much that somebody is saying
I think,
that
1 second, Rakesh, I think Mr. Sorabjee wants to. Yes, Mr. Sorabjee.
Well, I think it's our duty to tell the public and to educate them that these differences between judges is nothing uncommon. In the first passport case, Justice Hidayatullah and Bashawar strongly dissented from Chief Justice Subbarao held. First passport case.
Right.
Besides, this is a media hype, as if because these differences which have always been there, but they were not so much put on the first page of the newspaper. That's what affects the public perception. So the public must be educated and assured that these differences have existed, will exist, but they should not be taken as a lack of independence in the judiciary.
No, I'm not
That's
talking.
important.
No,
I
I'm not
agree
talk-
with you. These things.
Mr. Sorabjee, there's no. We're not.
You see, we are doing a disservice.
We have not come to the issue of lack of independence yet. But when a former Supreme Court Chief Justice has to come out openly and say that I have not been biased, when one of the former Chief Justices of a state High Court, hints at him not being elevated for certain reasons, aren't these things very unusual?
No, that is very unfortunate. I agree with you.
Do you
That is
think
very
that
unfortunate.
these kind of things have ever
That's
happened in this
distressing.
country? Yes.
No, I agree with you. That I'm in all agreement with you. It's distressing. Chief Justice of Gujarat also,
Yes.
if he has something written to the President or whatever it is, he did not have to go public.
Exactly.
And did you read his statement?
Yes.
That also was not lacking in restraint. Rape of the judiciary and all
Right,
that.
right.
And look at the position in which former Chief Justice was placed. If he didn't give a response, it would appear that he agrees to everything that was stated.
Absolutely.
He has made his position clear.
Right.
That when it came to the appointment of his sister, he had recused himself.
Right.
But I agree with you, this sort of arguments and counter-arguments really,
In
I
public
find it most distressing.
In public
Most
space.
distressing.
In public space. Yes, Mr. Professor.
Sorry, let
Ranbir.
me illustrate another principle
Yeah.
which says confidential information acquired by a judge in the judge's judicial capacity shall not be used or disclosed by the judges for any other purpose not related to the judge's judicial duties. Now,
Absolutely, yes. This is being, very unfortunately, it has been violated. Yes,
see, the
Rakesh.
principle laid down in that CVC case,
Right.
if you said, that was institutional integrity. That was the only ground on which they said, no, the then CVC has no business to stay in that position and somebody. So why the same principle cannot be applied in the other constitutional,
Constitutional offices.
absolutely, in all, not one.
For all the constitutional
Yes.
offices. Yes, but but do you think that this kind of public interaction between judges had ever happened before?
No.
Have you in your
You
own
see,
experience?
what I have observed, you will also appreciate that for past say 10 years or so, whenever a Chief Justice is retiring, then a lot of things are said about him.
Right.
Or in another case, somebody is taking over.
Right.
Throughout that period, when he was a judge or a high court judge, or nothing is said. The moment he is leaving, you will come across with so many things. Or if a new person is coming in, you will find. But there is hardly any debate or any discussion or any information is disclosed about the new incumbents who is coming to the High Court for that matter.
Right.
Ultimately, they come to the Supreme Court.
Right. So, Mr. Dua, you think again this will go back, all these discussions and debate on this, we'll have to go back to the issue of appointment of judges? Is that where the problem lies?
That's not the only problem, but that's certainly a serious problem on the appointment of judges. Now, the Supreme Court itself has taken all the powers of appointment
Right.
in 1993,
Right.
reversing the decisions of 1973 and all that. Now, collegiate function has been, appointments have been given to collegium.
Yes.
Now, functioning of the collegium, by very nature of work or otherwise, is very confidential.
Yes.
But openly, the judges, not open in the court, but privately, they have been maintaining that this system is not working. Judges themselves have been saying.
Are admitting it.
The reason being, a lot of bargaining takes place between one judge and another. There are 5 people in the Supreme Court judgment. No, normally the seniority principle is followed for the top post. But when 3, 4, 5 High Court judges have to be appointed, and from High Court Chief Justice, they have to be brought to the Supreme Court, again it goes to collegium.
Yes.
The executive has not much of a role.
Has no role almost.
Practically
At all.
no role.
No.
Practically no role.
Yes.
Unless confidential reports are sought by the Intelligence Bureau and all those kind of things. Now, there have been differences among the collegium members on appointment of judges. Now, these differences have been coming into the open.
That is
Now,
what is
that is sad
that is
part.
what is very is a matter of
That's
serious
what.
concern. Let me get Mr. Sorabjee on this.
No,
Mr. Sorabjee?
there is a problem on one.
Yes.
There are no set criteria for what kind of judges Supreme Court needs.
Exactly.
Now, I want to make this one small point
Yes.
there. Delhi High Court came out with a judgment several years ago, laying down criteria for admission into nursery schools, in Delhi nursery schools. There are no criteria because people don't know what criteria are needed for becoming a Supreme Court judge.
Mr. Sorabjee, is there where the problem lies in the appointment process itself? Do you think that is where the problem lies?
Yeah. And let me tell you 2 things. First of all, there are of course criteria. The collegium also goes by for example, it's a High Court judge, they know the quality of his judgments, they know his general reputation, they know his standing at the bar. But the question is, the problem is, the collegium system were very well designed initially to prevent Sarkari judges from being appointed. Unfortunately, in practice, hasn't worked satisfactorily. So I think the real solution is, we require appointment of judges most important, because to remove a rotten egg is very difficult.
Yes.
So they should be replaced by a National Judicial Commission, whose composition also of prime importance. And in my view, that commission must have the point of view of the executive. This is the only country where executive has no say in the matter. So to my mind, in that commission, judiciary may have the dominant voice, but not exclusive voice.
You think that this commission should also...
The executive, we have a law minister.
Mr. Sorabjee, do you think that this kind of a commission should not only... This kind of commission should not only have the authority to appoint judges, but also to probe complaints against the judges, if any?
No, one minute. Complaint is entirely different. That's the Judicial Council. Complaint is for removal.
Yes.
Now we are talking of appointment.
Yeah, no,
so why?
yes.
The other democratic countries, South Africa, there's a commission.
Right.
In London, in UK, there was a commission.
Right.
So this can't be. Judges can't appoint themselves. That's the problem.
How is
if we throw out the collegium system, if it's not satisfactory, let's replace it with something also effective.
Why do you think that despite the debate having gone on in this country for quite some time now about this collegium system not having worked, nothing seems to be happening still? You think there is a lot of resistance from the judiciary itself?
Well, I suppose so. But though Justice Verma, who gave the first judgment, was frank enough, late Justice Verma himself conceded that it's not working properly.
Right. Okay. Mr. Dua?
I
You
think Soli is
And
absolutely
I'm not
right.
too sure whether it wouldn't require a constitutional amendment.
does it require? It doesn't require.
Girish, Soli is absolutely right
It may require.
Oh, it may
It
require.
possibly does.
Okay.
that the judges have not handled the appointment satisfactorily.
Right.
Second, you cannot have Sarkari judges, not all the powers, but you can't exclude executive. You can't
The
exclude,
whole idea of this
you
collegium
can't
was to have not
so
to have
you-
Sarkari judges.
You have to have a mechanism
Mr. Dua?
which is
No, no, Mr.
independent
Dua,
of the government,
no, when this-
independent of the judges also,
No, this-
to select new judges.
No, this collegium system, when it was adopted, because they adopted themselves, the judiciary themselves adopted it. The whole idea was not to have Sarkari judges, isn't it? Mr. Ranbir Singh?
I think I have two very pertinent points to make. One is the architect of the present system was the Supreme Court itself.
Yes,
And it has no constitutional mandate,
right.
to my mind, as an
Right.
academic. You don't find any provision in the Constitution of India saying
There's no mention of a collegium.
there is no
anywhere.
mention of the collegium anywhere. But my concern is that you remember that when we were appointing Chief Justice of India for a long time, and there have been controversies.
Yes.
Some very able judges of the Supreme Court
Have been superseded.
resigned because they were superseded. And then we invented the precedent that the senior most judge would be the Chief Justice of India.
Right.
And I sometimes as an academic wonder, when you take a person to be the Chief Justice of a particular High Court, and when somebody has to move to the Supreme Court, then there are all kinds of allegations, and you don't elevate a person to the Supreme Court.
Right.
If a person is no good as a Chief Justice, he is no good as a Supreme Court judge, why can't you apply the same principle to the Chief Justices, that they can be appointed on the matter of seniority? And this whole debate will go. Why pick and choose and say so and so cannot be promoted, so and
why
so
even
can be
transfer
so
such person?
and even for that reason transfer. I think we need to have a more transparent system.
System.
I think the Judicial Appointments Commission, which,
I think
which Soli has said, that meets the needs.
There's a strong brief for the
That's
Judicial
a,
Commission.
that's a,
now.
it
Another brief
takes care of the unnecessary interference from the executive.
Hopefully.
It also takes care of the unsatisfactory selection by the collegium. So it takes care of both, and you have to provide a fair amount of independence to this for making the right kind of
In 1993,
appointment.
it has said
Let
that
me have a public debate.
it was important to know the law minister than to know law to become a judge. Now there is a parliamentary committee report which suggested that, well, the appointment is what? Uncle judges and auntie judges. You know?
Yes, that is, this is not a laughable matter. It is something,
Yeah,
a matter of
absolutely.
very serious concern, actually. Mr. Sorabjee, another issue, then the talk of independence came here. Autonomy, when we talk of independence, there is also the issue of accountability. I'm sure you remember, I was just going through Justice Kapadia's MC Setalwad Memorial Lecture, in which he has some of the things which he has said are something which this country has been, and he has been so frank in his speech which he made, that Setalwad Memorial speech. Some of the most
But there's no
traditional-
dispute.
Yes,
No, but there's no dispute. There must be accountability. One accountability is on the judicial side.
Right.
You have an appeal, further appeal to the Supreme Court. When you mean accountability for misconduct, accountability of misbehavior for exercising judicial functions, then we go to different field. There
Right.
should be a different body,
right.
by judicial council, and that you must be very clear about its composition. To my mind, it should be comprised of distinguished, eminent judges, no litigants participating there, because whilst ensuring accountability, we must ensure that independence is not compromised.
Mr. Sorabjee,
That's a very delicate thing, and that to my mind.
absolutely. Mr. Sorabjee, I just want to read
But
one.
if I may say one thing,
Ma'am,
the
Mr.
question of removing judges,
Yes,
just let me add one thing.
Yes.
The question of removing judges would seldom arise if proper appointments are made. So that's the very thing.
Absolutely.
Let's go to the root of it.
absolutely.
Assure a mechanism which will make, you can't be perfect in every case, but avoid the possibility of improper appointments
Absolutely.
or unsuitable appointments.
I just want to read one sentence from Justice Kapadia's Setalwad Memorial speech, in which, talking of judicial accountability, he says, there is no reason why the judiciary should not be accountable to the community for its due performance of the functions vested in it. Power is given on trust, and judicial power is no exception. In fact, Justice Kapadia goes to the extent of saying that
Correct.
that the accountability should be to the community. It's not just within the community. To the larger community. I suppose he means the larger community. Mr. Sorabjee?
Hello?
Yeah.
Haji?
And
Sorry.
so when he talks of accountability to the community,
No,
what
no,
do you
I mean,
by this?
no, correct, but that's not, community doesn't mean the dedicating public
No.
after the question.
Okay. So
Community means to a body which is properly constituted and which is go into the question of judicial misbehavior or misconduct.
right.
In that body you can't have litigants, because here if every time a litigant loses, the judge was bribed, the judge was got over. Unfortunately, even some senior advocates don't say the judgment was erroneous. Oh, the judgment was dishonest. Now we can't have that. We have to keep the balance.
Right.
As I said, enforce accountability without compromising independence.
How do you, Professor Ranbir Singh, how do you enforce accountability
Let
and
me
compromise independence?
let
That
me
is-
again refer back to the Bangalore principles.
Yes.
In the preamble, three cardinal principles are very, very pertinent for this discussion. Says, whereas public confidence in the judicial system and in the moral authority and integrity of the judiciary is the utmost importance in the modern democratic society, right? Second is, it is essential that judges individually and collectively respect and honor judicial office as a public trust. That
Exactly.
is accountability, right?
Mr. Dua, we are running out of time. Mr. Dua, we are completely running out of time. I just want you to say this tendency which is growing of seeing these kind of conflicts coming out in the open is how do we tackle this? Or do you think? I'll come back to my formulation whether this will lead to some kind of a catharsis.
I have a feeling much depends on the selection of judges.
Okay.
They must have integrity, character, and the stature also is very, very important. It's not just the seniority.
Yes.
Even in seniority, stature is required where the public acceptance of the judge's word should be taken as a last word. When you reach the Supreme Court level, every word that comes from the mouth of any judge should be the last word. Now, that kind of moral prestige when the
Correct.
that kind of moral prestige when the court exercises is with a wider acceptance, and the question of accountability will not arise.
Right.
The problem arises when mediocre people become to the Chief Justice of High Court and some of them land in the Supreme Court, then the moral authority of the court suffers in a big way. One bad egg can spoil the image of the entire court.
Absolutely.
Now, that moral authority Supreme Court has to acquire, and that can be acquired only if you select the best of the people with integrity and character and put them on the bench.
Okay, Mr. Sorabjee, last words to you very quickly. You think that this kind of public display of disaffection towards each other is something that something which has to stop immediately, and how will it stop if it has to?
Well, first of all, how did it start? The Chief Justice of Gujarat making all kinds of allegations in his statements, and which were not, if they were not controverted, it will be taken as accepted. So it will stop by any person holding judicial office being conscious of the fact that he belongs to a judicial family, and if there are any differences, don't air them in public. Air them before the constitutional authorities. I can understand if you wrote the letter to the president or any other authority. Not in public. Don't release these letters in public. Because public naturally gets perplexed and disturbed. Okay, what are these judges calling on themselves and flinging allegations and rebutting them with counter allegations? I agree, this trend must stop.
Okay.
I was frankly most disturbed when I read this.
Okay.
I've never come across it before in
Okay.
public.
Okay. Okay, on that
also
note,
now.
I think we have to completely run out of time. The fact of the matter is that the issue of judicial system giving that kind of confidence to the people is very, very important, because judiciary is the last bastion on which the people of this country still have some faith. So the people in the judiciary need to understand that faith which people have in them. Thanks to all my guests, Mr. Soli, Sorabjee, H.K. Dua, Professor Ranbir Singh, and Rakesh Bhatnagar. Please keep watching. We'll come back with another issue in the big picture same time tomorrow.